Okay. Okay. Good evening, folks. Thanks for those that are attending and online or otherwise or on Facebook at any time. My name's Greg Perrick. I'm the review counsel at Community Legal Services Clinic at Western Law. I am the Family Law Review Counsel, and that's why today this appearance will, or this presentation will be with respect to family law. It's just general information today, and we'll get into that. I have with me Mackenzie Leclerc. She's a law student, a first-year law student at Western Law. She's a keener with respect to family law. And she will be helping me out, or actually doing most of the work tonight with respect to the presentation. It'll be a short kind of bite-sized bit of information with respect to be spoken to court, and Miss Leclerc will elaborate on that. So we'll go from there. What I'm going to do now is I'm going to hopefully smoothly and swiftly share the screen here so that we can run the presentation for you. So just give me a second while I make my way through this. As you can see, I'm very tech savvy. Just a moment. Okie dokie. I'm going to rely on Mackenzie here to tell me that she can see the information.
Yep, I can see it perfectly fine.
Okay. Okay. So I'm just going to back up here. Thank you for that. So, as I alluded to, tonight's presentation is with respect to be spoken to court, or as Mackenzie will explain, it's also identified as TBST court. And she will kind of explain more specific information with respect to that. Before I go into that, it's incumbent upon us and important for us to do a land acknowledgement. Okay. And so Western University, I acknowledge that Western University is located on the traditional lands of the Anishinaabe, Haudenosaunee, Lenape-Wauk, and Chinookan nations, on land connected with the London Township and Sombra Treaties of 1796 and the Dish with One Spoon Covenant Wampum. With this, I respect the long-standing relationships that Indigenous nations have to this land, as they are the original caretakers. I acknowledge historical and ongoing justices that Indigenous peoples, First Nations, Métis, and Inuit endure in Canada, and we at Western accept responsibility as a public institution to contribute toward revealing and correcting miseducation, as well as renewing respectful relationships with Indigenous communities through our teaching, research, and community service. I just want to be clear that we at CLS, at the Community Legal Service Clinic, and those at Western, this is not just something that we are paying lip service to by saying this today. This is something that we endeavor to internalize and really pay respect and address to, and to be proactive on this. So we want to impart that we take this seriously, and this is not just something to get through. So thank you very much for letting me go through that. I want to let you know that this is not a legal advice session. This is public legal information presentation. So it's more about general information for the public as to how to move through in this presentation tonight, how to move through to be spoken to court on a general basis. There will be a Q&A session that I will be holding after Miss LeClaire has done her great presentation, but be mindful that there's no confidentiality. In the next slide, we'll talk about that. But there's no confidentiality with respect to anything you ask me or tell me. So please keep your information anonymous. Keep it general, and I can only give information. I can't give you kind of specific advice with respect to your specific case. Okay, so just be mindful of that, and be mindful that this is going to be, as I said up front, that this is a recorded session. So other people will, if you do say something that is specific and private, other people are going to see that. So please be mindful of that. And again, as I said, just in the last slide, no confidentiality, and that this stream is being boosted by the Rights and Responsibility Awareness Institute. I see that Heath Karki has joined us. He is our compatriot in getting this information out for the public. He's made this possible so that we can really get as wide as possible a net for folks to get this information as widely as possible. So we thank him for that. I'll just give him a beat. I don't know if he wants to say a couple of words. I will let him do that if you'd like.
Thank you. Thank you, Greg. And it's an honor to collaborate with Community Legal Service in order to publish and promote those information sessions, which contain a very important information that is very useful to public. So I would like from this point to thank you for this kind collaboration. I would like to thank Community Legal Service and Western Law students and the administration for all of this kind support and for everything you have done and you are still doing to the community.
Thank you very much for that. We are endlessly grateful to your agency for assisting us on this. So thank you for that.
You're welcome, sir.
Just know that Miss LeClaire will be she'll be doing all the work. I'm just going to sit back with my feet up. She is going to be giving the presentation tonight. Just know, as you can see on the headline there, that she cannot give legal advice. And really, in this presentation, I can't either. With respect to the Q&A, I can try to give general information and try to steer you in the best place possible. But I can't give, again, kind of legal advice given the public forum. And despite their growing knowledge of the law, which is, I can tell you with Ms. LeClaire, she is well ahead of where I was at her time, and still she cannot give that information. So I just ask you to keep that in mind. So I'm going to bow out until Q&A, and I'm going to give this to Ms. LeClaire. And thank you for hearing me ramble on for a bit. Thank you.
Thanks, Greg. So as Greg mentioned, my name is Mackenzie LeClaire, and I'm a first-year law student at Western and associate caseworker at Community Legal Services. So I'm really excited to give this presentation to you today. So a to be spoken to, or a TBST, as Greg mentioned, is a virtual court appearance that essentially allows the judge to see that you're doing what you're supposed to be doing to keep your case moving forward. It's a case management opportunity that's strictly procedural, where parties can update the court on what the next steps in their proceeding are going to be. In London specifically, these appearances are generally held on Tuesdays starting at 9 o'clock on Zoom. I'll talk a little bit about Zoom etiquette later, but it's important to be aware that there can be over 50 cases on a docket each Tuesday morning. And a docket is a list of cases that the judge is assigned to address. And if you're not already given the docket, you can access it anytime, I believe after 4:30 p.m. on the day before your appearance through ontariocourtdates.ca. I'll post this link in the chat at the end of the presentation, along with some other resources as well. Go to the next slide, please. Perfect, thank you. So the judge will not have read any of the material in your case prior to the appearance. Because of the size of the docket, it's impossible for them to address non-procedural issues like making decisions about child support, decision-making, and parenting time. There's simply just not enough time. And if they were to determine non-procedural issues, then everyone on the docket would be held up in court all day and probably into the night, and nobody wants that. Regardless, the judge can't address anything beyond procedural issues because they don't have benefit to any of the material pertaining to your case. We really want to drive home this point that the purpose of a TBST is to move cases forward to the next appropriate step in the proceeding, whatever that might look like for you. As I mentioned earlier, TBST appearances are held over Zoom. When you log into the Zoom courtroom, make sure that your Zoom name is as the name that shows up on your court documents. And when you're editing your name, you can also add what docket number you're on. Judges are very busy people, so it's important that everybody comes prepared and organized. It will make your life a lot easier as well. And equally as important, remember to keep your microphone muted and your video camera turned off until your matter is called, or if you're in the registrar's court at 9 a.m. and want to speak to your matter then. So this leads into the next portion of the information session. TBST appearances occur in two stages. At 9 o'clock a.m., you can speak to your matter before the registrar. After 9:30, you can speak to your matter before the judge. But what does this mean? For those unfamiliar with the term, the registrar, they're the person responsible for the administration of the court. This includes scheduling, preparing documents, maintaining order and decorum in the court, and addressing technical issues. The registrar can only deal with matters that are being addressed by the parties on consent. And these are situations where both parties agree on the next steps in the proceeding. The registrar will ask something like, does anyone have an adjournment on consent? So if your matter is on the docket and is on consent, then you can speak before the registrar between 9 and 9:30, and that way you don't need to wait for the judge. Otherwise, if it's not on consent, your matter will be called before the judge in order of the matters on the docket. But yeah, please remember that you're only able to deal with your matter before the registrar if both parties agree on the next steps. Otherwise, you have to wait for the judge to hear your matter. If both parties are unrepresented and you want to call on your matter before the registrar, then you need to know the following, which you can see on the slide there. So you'll need to know your court file name, which will be your last name and the other party's last name, the docket number, and your file number. And before you hop on the Zoom call, just make sure you have this information on hand, as it'll go a lot smoother. And in my experience, feeling prepared usually means a little bit less stress. You'll have to unmute your microphone and turn your camera on because you'll have to ask the registrar to speak to your matter. Best practice is to ensure that you're not speaking over anyone. If someone else is talking, just wait, keep your camera off and your microphone muted. You just don't want to confuse the registrar and ultimately cause a delay. When there is an opportunity to speak, you can unmute, turn your camera on, and you can say exactly what's on the slide there. Say good morning and draw their attention to the docket number, court file number, and court file name. This will make the process go much easier for them. And once you've called on your matter, you can let the registrar know what date you're adjourning to and what for. They also have access to a list of dates for TBST appearances, so you can always ask them if you don't know what date you're adjourning to. It's important to remember that since you're speaking before the registrar, you should know what your next steps are since you've agreed on them with the other party. Otherwise, if you haven't agreed to anything, you'll have to wait for the judge to appear on the 9:30 a.m. list. So the judge's list usually starts at 9:30 as long as there's no technical errors on outside of the court's control. And they almost always address matters in the order that they appear on the docket, like I mentioned earlier. So just ensure that you know your number and that you're keeping track of where they're at in the list. And again, double or triple check that your video and microphone are off when you're not speaking on your matter. You don't have to call on your matter if you're on the 9:30 a.m. list because the registrar will call on you, but you do have to wait. Here is a list of things to consider prior to the TBST, and I'd recommend having notes about what you want to say about your matter, or even some kind of script might be helpful for you. So when your matter is called, you should know the following: whether your case was started by way of application, motion to change, or a contempt motion, the purpose of your last appearance in court. Did you have your first appearance or first return of application or motion to change? Have you had a case conference or a settlement conference? Think about where you'd like to go from here so that you know what to tell the judge. You'll be looking at different options depending on where you're at in your case. So what you'll ask the judge for is entirely dependent on your situation. So if you need assistance on that day or prior to that day to prepare, you can contact duty counsel. And I have a link to their contact information on the last slide, which I'll also paste in the chat afterwards. You can think of a TBST as a placeholder date to track the progress of your matter and briefly update the court on your intended next steps. If you're sort of sitting in limbo, you're waiting on information from the other side that they've been ordered to give, or you're waiting on third-party information, it would be wise to book another to be spoken to. So that's something that you can mention to the judge. And then here are some other things to remember just before I wrap up here. So when you address the judge, you refer to them as your honor. You can speak directly to the judge, but not the opposing party or lawyer directly in the court. Don't talk over the other side, as this is very distracting. Ensure that you're muting yourself when the other party is talking, and keep your comments to the point, which is why I recommend preparing notes beforehand, especially if you're looking to book another to be spoken to. You'll want to tell the court why. And the last thing that we want to emphasize is that it's more than okay to ask for help and to use free legal resources available to you. I'll paste these links for the folks that are here in our Zoom chat if you'd like to check them out. They're very helpful. And otherwise, Greg will now be answering some general questions, so I can pass the torch off to him. But thank you so much for listening. And if there's anything you need clarification on, I'm sure Greg could do that.
Yes, thank you, Mackenzie. That was great. And as we kind of said in the beginning, that I know it's a bite-sized kind of piece of information, but very, very important on to be spoken to days, as it can be very overwhelming. As Mackenzie said, there can be at times 50 plus cases before their honor, the justice, and like Mackenzie said, they don't have the benefit of reading your file back to front. And I just see that Mackenzie copied and pasted the links for other resources that could help you. What I would always say is the more in advance you can contact these resources for assistance, the better. Even with duty counsel, contacting them on a Monday for a Tuesday appearance, while still, appropriate, may not get you assistance as soon as you need it, or before your appearance. So really think about that. One of the most frustrating parts that I see unrepresented parties have, those without a lawyer, one of the most frustrating things I see them have or experiences they have in to be spoken to court is the fact that they can't speak to their matter, in a concrete way. It really is just more of a procedural appearance to say where you've been and where you're going to go next. The judge just doesn't have the capacity nor the information to make any kind of what we call substantive decision on your case. And that just means, we can't make a decision with respect to child support, can't make a decision with respect to decision making, can't make a decision with respect to parenting time. So really keep that in mind, right? Because I can imagine it's very frustrating as someone who doesn't know, the legal part of it, to think I'm going to talk to a judge today and I'm going to get them to tell me how this case should go. Unfortunately for Tuesday TBSTs, that's just not the case. It just can't happen. They don't have the capacity for it. And as Mackenzie rightly pointed out, if they had the time, or if they had the information rather, to kind of speak on your case, folks would never get out of court. So it's incumbent on us to be prepared as possible, even lawyers, right? To really have the information ready and loaded for the judge as soon as they ask questions. So you can never be too prepared, which I think should be the takeaway. So if anybody has any questions, you can put them in the chat, or you can unmute yourself, or show your video, whatever you're comfortable with. But I will hang on the line for a reasonable amount of time to see who has any questions. If you don't, that's fine. Those resources that Mackenzie has provided are just as good. There's no magic to what I would tell you anyway, because I can't give you specific advice, but the general information part of it, I can try to help you as best as possible. If nobody has any questions, that's fine too. I just thank you for attending and listening, because this is a really, I think, helpful bit of information for the public and those who are going to court, because even for lawyers, it can, it can be unpredictable at best. And that's nobody's fault. It just, we have a big caseload and only so many people. So thank you very much for listening. I'll just wait a couple of moments to see if anybody has any questions. And then if nobody has any questions, we can wrap it up. But as we've said throughout this is going to be available on a Western Law website, Facebook. This is going to be available on Rights and Responsibility Awareness Institute's websites. I see that Mr. Karki's still online. I don't know if he wants to copy and paste anything in the chat. So if he hasn't already. So there's information with respect to that.
Thank
Okay.
you, Greg. Well, currently I don't have anything to post, but I would like to let our audience hear that those information would be available in multiple languages in
Okay.
RRAI website and social media platforms as well.
Perfect. Thank you for that. So I'll just wait a couple of minutes. I see a couple people in attendance. If you have any questions and they're general, I will answer them as best as possible. Okay, I see a question in the chat from a myth as a party. What if happens if my opposing party does not show up to the TBST? Well, it would really depend on kind of this scenario. So if you are somebody who, if you are the party that started the proceeding, and you've served and filed your, say it's an application that started the proceeding, or you served and filed your motion to change a final order, and that party's been given 30 days to respond to it. Well, they have to have 30 days, and you arrive to your TBST, which would also be called a first appearance at this point, if it's your first appearance. You could potentially ask for a uncontested trial. I don't want to go too further into that because that would probably be a whole other presentation, but that is potentially something that you could ask for if another party hasn't responded to your initial paperwork that started the proceeding, and they have 30 days to do so, 60 days if they're outside of Canada. But if they don't respond, you could ask the court to book an uncontested trial. What I would say to that, though, is that just be aware that uncontested trials are and I mean, you have no choice to book one, but to book one if you're in the situation. But be mindful that uncontested trials are being booked far away. It's just a reality of the court system at this time. So, one of the biggest things that, and Mackenzie alluded to this earlier in her presentation, patience. And I know that's easier said than done, but patience. Just by way of an example, generally we had a case. I booked an uncontested trial in October, and it's not to occur till August of next year. It's shocking, but I mean, through no fault of anybody. I'm not faulting the court, but that's just the reality of our situation at this time. So patience. I hope that answers your question, Miss as a party. Any further questions? I tell the students all the time, and it's true, there are no stupid questions, no silly questions. So please don't be shy about that. Where do I find the date and time for my TBST if I can't remember when it is? Mackenzie, do you know this?
I'm learning from you, Greg.
Okay. So what we do at Community Legal Services is we find the date two ways. So there's what I do just generally is the Google or Bing or whatever your preferred search engine is. You would put in daily court lists, and that's a way to find out the next day or that day, either or, what cases are being heard that day, when they're being heard, and perhaps what courtroom they're in. That's not the court docket. that is just general information, public information with respect to when something is going to be heard, generally what the purpose of that appearance is, and then perhaps what courtroom it is. The docket is specifically what the court's list of cases are going to be. Specifically, each and every case. So you'd have Smith v. Smith, Jones v. Jones, etc. And it would tell you what number on the docket you are. To figure that information out, more specifically from my perspective, and Mackenzie can tell me if there's any more resources. We go to Midlaw, and that's the Middlesex Law Association, a website, and they have some information with respect to the daily docket, and you can download that there at Midlaw. Thank you, Mackenzie. She just put it in the chat, and you can go there, and you can download the daily docket for the next day. And as Mackenzie said, that's available. If possible, and usually, barring some tech glitches, it can be available 4:30 p.m. Or later the evening before, and you can find out when your appearance is occurring. You can have the link. You can see the judge who is going to be sitting that day for it, and then you can get the docket. Getting the docket sometimes can off of that website can be tricky because it's PDF. And what I do when I want to get it is I will download it, and then I will click on it, and then I will get it. Then you have to be sure to click, if you use a Word doc, to enable editing, and that will be. Once you do that, you should be able to click on the PDF, and the PDF will come up. And the PDF will show case after case after case in order. And whatever number you are on that list, that's called your docket. That's called your docket number. It's not your court file number, but it's your docket number. I encourage you to look at the slides that Mackenzie presented, because it does talk about what your court file number is and what all those numbers mean. And I'll be frank with you, it was well into my career until I figured out what these numbers meant. So do not feel kind of embarrassed that you don't know what your court file number is. So I encourage you to look at that. If you can't find that information with respect to your when your TBST is, you can call the London courthouse, and you can call their main number. I don't know, Mackenzie, is that in the information, or if you can just kind of pull that up and copy and paste it?
Mm-hmm. Yeah, of course.
Yeah, thank you. You can always call that main number and say, I have a court case today in family court. I think it's to be spoken to. I don't know where the link is. How can I get that? I can tell you that I'm sure you're not alone in that, and so there's lots of folks calling. And thanks, Mackenzie. She just dropped that number in the box. You keep calling. If there's a lawyer on the other side of your proceeding, call that lawyer, email that lawyer, ask them if they have the link, if they can send you the link. That's not an unreasonable request, so don't be afraid to do that. You have the right to that information and the right to know how to appear for your case. So that's generally how you would kind of track down that information. I know we've got to find better ways to make this information more readily available. You shouldn't have to go to one particular website to get that information. And we will do our darndest to try to push to get that information more available. I think that long-winded answer probably addresses Miss Azzopardi's second question. She has lots of questions, which I appreciate because that just gets more information for the public. So thank you for that. Any further questions? Yes. So I see another question there from Miss Azzopardi. So he's asking, how do I know if I'm in the right Zoom courtroom when I get there? Can I ask the registrar? Most certainly. So you heard Mackenzie talk about the 9 a.m. list, the registrar's list. So if you are uncertain, I cannot encourage you enough to use that opportunity from 9 to 9:30 to get on the registrar's line, and ask if you're in the right courtroom. That's probably the best time to do it. It is the best time to do it because the judge isn't sitting and it's more of an informal atmosphere. But then just remember, if you get on the line and you're trying to find out what's going on, if somebody's talking, don't obviously jump in because I know personally, sitting on Zoom lines for quite some time in court, the moment two folks start talking or more folks at the same time, it's just a wall of sound and nobody can hear anything. And then it just delays and delays. So make sure that you wait when you get in there, but certainly there's nothing wrong with once there's an opportunity to unmute, take your video off and say, Madam Registrar, Mr. Registrar, Mr. Registrar, what would you, am I in the right courtroom? My matter is Smith v. Smith. This is my court file number. I think I'm supposed to be in Justice Blank's court. Is this the right courtroom? Okay. But the more information, as Mackenzie told you in the presentation, the more information that you can have ready for the registrar, the easier they can tell you where to go. So, don't be afraid to take notes. Don't be afraid to ask questions because the court should be focused on access to justice. And what that means is access to justice for everybody, those who are unrepresented, especially. You have the right to know information with respect to your case, general information, what's your court file number, what's your case name, things like that. So the more prepared you can be with that general information that we've talked about tonight, the more or the smoother and less stressful, because family court is stressful for the best of us, the less stressful it will be. Any more questions? Good question again from Ms. Azzopardi. What would happen if I miss my TBST by mistake? Does it get moved to another day? How will I find out that information? So if you miss your TBST, the best thing to do is, so if there's a lawyer on the other side, contact that other lawyer. Let them know that you missed it by mistake. The sooner you let them know, the better. And I can understand that it's hard to contact a lawyer and as an unrepresented party, but the best thing you can do is to reach out to them, even by email, if you don't want to make a phone call. And I get that. Let them know you missed it. Here's why I missed it. What can we do? If you don't hear anything, call the courthouse. The number that Mackenzie dropped in the chat. Cite your case number. Cite the file name, Smith v. Smith. Cite the last day you were in court. ask when the next court date's going to be, because I missed it. And if nothing else, if you're not able to contact the other side for whatever reason, you're not able to contact the lawyer, make it to that next date that you find out, and let them know that it was an accident, that you missed it or whatever reason. But just missing, do your best to not miss the court date in all circumstances. But if you do miss one by accident, the best thing you can do is react immediately. Let the other side know. Call the court, find out when the next date is. Any more questions? There doesn't have to be. Just want to make sure that everybody has a chance to ask questions with respect to Tuesday morning TBST court in London specifically. I will say that generally these kind of concepts or principles or ideas that we've been talking about probably generally apply to all regions, especially if you're non-rep. Being as prepared as possible is always, you can't go wrong with that. Know that general information that we provided in the slides. You can't go wrong with that. What I do know is in different regions, they kind of use different terminology with respect to certain appearances. To be spoken to court is probably the same across the board. They would call it to be spoken to court. Some regions kind of split up what we would call Rule 39 court and to be spoken to court. But I'm not going to elaborate on that because I don't want to confuse anybody. But just be mindful that every region may have some small differences, but the principle about being ready and knowing where you've been and where you want to go in your case is always helpful. Any further questions? I'll just give to 542, I suppose, or 543. It just turned 542. And then if there's nothing else, we'll stop recording. But again, this is available, will be available across the board afterwards, as Mr. Karki kindly said that this is going to be translated into multiple languages, which is absolutely awesome. And we're happy that we're getting this information out to those that it can help. Use the resources that we have at the end in the last slide that we provided. I don't know if I can go back up to kind of just show that again, but it's also in the chat. Do not be shy to use these services. There's no doubt that court in general, but family court can be a maze to navigate. So you're not alone in this. I've been doing this 10 plus years, and I can still feel overwhelmed by it all. So thank you for attending. 543. I'm going to stop recording. And I thank you, everyone, for attending. Thank you, Mr. Karki, again, for partnering with us. It's essential and vital that we pair and that you continue to partner with us in getting community information. It's priceless. Thank you for that.
You're welcome. By